Kia ora and welcome to the programme. Every working day, up and down the country, thousands of people working in the public service, like regulators, are giving decisions in practically every area of interaction is possible to decide anything about. If that's you, the power to make that decision may come from legislation produced in that building behind me, Parliament. Or it may come from regulations produced by a minister in the beehive over there. Wherever the power comes from, most government decisions can be challenged by those affected by them in a different sort of building entirely, the court. The courts are where the business of government meets the rule of law. It's the courts that make sure that those decisions are lawful. The ability to take the government to court and challenge those decisions is a process and an arena, judicial review.
Well, good decision making is an important objective in its own right. It's not just when decisions are challenged that we want government decisions to be good ones, and the public should expect that from any decision makers in government, whether it's ministers or in departments. Good decision making is critical. And it's critical because successive governments get their legitimacy from their commitment to the rule of law. So good decision making is a rule of law commitment. The great thing about New Zealand is that we have an independent judicial system that oversees public decision making. And so again, the public can be confident that they have a place to challenge decisions if they wish to, whether it's through the courts or it might be through other places like an ombudsman, a privacy commissioner. Good decision making will always help. Whether decisions are challenged or not, that is the way that decisions will be clear, powers will be exercised appropriately, relevant matters will be taken into account.
If you're a regulator, then this programme is for you, because you make decisions and shoulder the burden of that. And that means also thinking about the judge over your shoulder. That's not an alternative and dramatic way of saying judicial review. It's actually a practical resource that can help you.
Te Pou Arahi is a resource that Crown Law has produced to help decision makers through a good process to come to their final decision. And we've brought it together by using real examples and by asking a series of questions and helping the decision maker answer them to really take them through that process. Of course, it's never a substitute for legal advice about a particular issue if that's required, but it will help decision makers and those who advise them in a really practical way work out what to do when they're making good decisions.
Judicial review is a challenge to the building blocks of the decision and the process followed by the decision maker. It's not about the outcome of the decision itself. Judges are loath to step into the decision maker's shoes. What they want to ensure is that process followed is lawful. Please come to your lawyers, get us involved early on in your decision-making process. We're here to help. What we want to ensure is there's no missteps or mistakes in the decision-making process.
So how does it all work? How do we make good decisions that are more judge-proof? Judicial review is about the building blocks of a decision, rather than whether what has been decided is wrong. This programme offers an overview guide to helpfully navigate those building blocks. But it's not a substitute for the judge over your shoulder guide or for getting practical legal advice from your in-house legal team who are there to help. When it comes to making good, more judge-proof decisions, the judge over your shoulder offers 4 clear building blocks or steps to making a good decision. Step 1. Preparing for the decision. Step 2. Getting the process right. Step 3. Making a good decision. Step 4. After the decision, recording and communicating. Preparing for the decision means checking you actually have the power to make one, as well as the power's limits. Section 45A of the Corrections Act is a good example. The source of the Chief Executive's power here is a statute. It imposes a duty, something they must do, about prisoners' property, and a discretion, something they may do, about conditions to do with that property.
We recommend that you include a description of the source of your power in the record of your decision making, and also that you record any limitations on the power that you encountered when you were making your decision. This will ensure that you can demonstrate that you properly understood the scope of the power in the event of a legal challenge. Another thing to note about powers is that even though the scope of a power might appear to be extremely broad, all statutory powers are limited by the purpose of the statute that extends them. So, for example, you couldn't use powers in an emergency earthquake legislation to make long-term planning decisions. Those kind of decisions can only be made if the statute provides for long-term planning, so something like the Resource Management Act.
Once you've identified the source and any limits that there might be on your power, the next important thing is to find out who can make the decision. The statute or the regulation that you're working under will probably specify who it is that can make the decision, or it may have been delegated. If the power has been delegated, it's really important for us to be able to prove that the delegation was in place before the decision was made. The easiest way for us to do that is to ensure there's a proper written record of the delegation in place when the decision's made.
Decision makers need to ask themselves whether there may be a relevant policy or guidelines they need to apply. Having policies and guidelines encourages certainty and consistency, especially if there may be a large number of similar cases. But they don't have the same force as legislation. They need to be applied sensibly, in accordance with their purpose, but not too rigidly. Policies and guidelines can't anticipate every situation that may arise, so a decision maker needs to deal with each case on its merits and think about whether there's anything special or significant about this case that may mean you need to depart from the policy. And if you do depart from the policy, you'll want to record your reasons for doing that.
Treaty of Waitangi principles, human rights and international law may also come into play. Take a look at the Judge Over Your Shoulder guide or your legal team for more on this.
One of the things that your legal team can help you with is consideration of whether there are other factors that need to be taken into consideration in your decision making, such as human rights, international obligations, and the Crown-Maori relationship. For example, the Treaty of Waitangi can be extremely significant and in some circumstances can amount to a mandatory relevant consideration. That is something that you must consider. Sometimes they also create process rights, such as an obligation to consult hapu and iwi. Any failure to factor these types of things into your decisions can result in the statutory decision becoming invalid. A good starting point is your legal team, but you may have other experts within your own organisation, and there are, of course, other Crown agencies such as the Crown Law Office that have particular expertise in these areas.
While a decision may have been one which the decision maker seemed to have the power to take, the way in which the decision was reached, the process, might be a cause for challenge. Was the decision made fairly?
The particular statute that you're taking a decision under may set out a process that you need to follow. If you fail to follow that process, it's highly likely that your decision will be invalidated if it is challenged. So in addition to those statutory requirements, it's also important to think about the decision you're taking and how it will impact on people. So a key element of good public decision making is fairness. And the greater the impact that your decision has on people, the greater the requirements of fairness. One of the most common requirements of fairness is providing people that are impacted by a decision with the right to be heard. If consultation is required, it's important to ensure that the people involved have all the relevant information and sufficient time to ensure that they are able to give informed and meaningful feedback. Of course, consultation is not a negotiation, and the decision maker won't be bound by the results of the consultation. It's just one of many inputs into the final decision. The key thing is that the people involved have been heard.
So bias is really around fairness, and it's not only around substantive fairness, but it's also around being seen to be fair. And making decisions free from bias is also around not having a financial interest in the decision, and also not having a personal interest in respect of one of the parties to the decision. And if you do, you've got to let the other side know. But freedom from bias is also around having an open mind, or coming with an open mind to a decision and not prejudging or coming to a preconceived conclusion. That doesn't mean you come to it with an empty mind. You can come to it with your experiences and your background, but you must be able to be able to make a decision with all the facts in front of you. Freedom from bias is essentially also around you being the decision maker. So not only do you have to take into account all of the information and relevant material in front of you, you must be the decision maker. You can't delegate that decision to someone else. You have to make it.
The need to check what expectations have arisen about the process can often be key to the decision-making process.
So there's 3 circumstances where legitimate expectation might arise: when there's been a promise to a particular person, or if there is a process outlined in a policy document or guidelines, or where a department has consistently acted in a particular way in the past. If there is a legitimate expectation, the court may expect decision makers to act in accordance with that expectation. It's generally going to be restricted to the process though, rather than the outcomes. And it is possible to depart from the process, provided that you have got good reasons for doing so, you have given proper notice to the persons concerned, and they've had some opportunity to comment on the proposed change. But your lawyer can help you to establish if there is a legitimate expectation and what you may need to do about it.
It's not just the process that's prone to judicial review, it's also the decision itself, the way it's built. For example, does the decision take relevant factors into account?
So, information that is relevant to a decision largely rests on 3 factors, and those factors are information that must be considered, information that may be considered, and information that must not be considered. In legal terms, we call these mandatory, permissible, or irrelevant considerations for a decision maker. So a decision maker must only take into account relevant considerations, and failing to take something into account that is mandatory or taking into account something that is irrelevant could lead to a decision being overturned. Now, guidance and assistance is available for decision makers through statutes and regulations that can assist in making a decision with the relevant information.
For example, the impact on the people of Tokelau was held to be a mandatory relevant consideration for New Zealand, considering its responses to climate change, given Tokelau's dependence on New Zealand and its status in international law. A failure to take their position into account would have been a breach by the Minister for climate change issues.
It's important that your decision is grounded in solid evidence. If information has been discredited or is based on mistakes, it should be an irrelevant consideration, should not be taken into account. If a piece of information that's critical to your decision is missing, then it's probably better to pause and make some further inquiries before you go ahead and finish off the process. Also, it's really important to be aware of the other information gathering requirements that might apply to your organisation. For example, the Privacy Act will have a range of controls over gathering, using and storing information that will be applicable to your decision process.
The courts are traditionally hesitant to substitute the decision maker's determination of the weight given to particular consideration in their decisions. So therefore it's up to the decision maker to decide what's important or not in making their decision. However, of course, there will be some situations where there will be particular things they need to take into account. Some statutes or regulations may say you have to have regard to particular factors in making your decision. Or there might be a court decision which means that it's determined that there are certain things you really have to take into account in making your decisions, or there are certain factors that you simply can't ignore. Your lawyers will be there to help. We'll help you and let you know if there's something that you have to particularly consider in your decision making, or if you can treat all the factors equally. We'll also ensure that you record your decision carefully and record the process and the observation in terms of how you've made it, so that if your decision's later challenged, everything's carefully recorded.
Having said all that, the courts may still sometimes closely scrutinise the actual decision itself, although usually it would have to be wholly unreasonable or irrational for the decision to be overturned. The threshold of what's unreasonable is more likely to be met if the decision has a significant impact on an individual's fundamental rights. Finally, properly recording and communicating the decision isn't just good business practice. If it's done inappropriately, it could be successfully challenged by way of judicial review.
All statutory decisions and any other significant matter, especially those involving a third party, need to be recorded. Keeping proper business records is a statutory requirement for all public entities under the Public Records Act and any other relevant act, such as the Privacy Act. In addition to these requirements, keeping a proper record of the decision is hugely beneficial if the decision is ever challenged. It provides the court with a record of what was in the decision maker's mind at the time that the decision was taken, rather than relying on something that has been produced after the decision has been challenged. A proper record of the decision and the reasons for it also helps to promote transparency and accountability. As well as thinking about keeping a record of the decision, you should think about who needs to be told about it and what should be included in that. There may be some things that can't be said, for example where privacy or confidentiality issues have arisen. However, generally, people that are impacted by a decision should be informed promptly of the outcome of the decision and the reasons for it. This will enable them to consider their options in a timely way.
So when should you seek legal advice?
We created Te Pou Arahi to help you make decisions and make them lawfully. If there's been anything in this guide that you're concerned about, please talk to your in-house lawyers. They're there to help you make good decisions. But nothing in this is about trying to stop you. We're not trying to stop you being entrepreneurial. We're not trying to stop you taking risks. With a good, clear view of what a good process will look like, you can take the decisions that you want to take, putting risk into the model the way you want to accept risk, putting the things that are important to you. Because of course your decision making, while it must be lawful, it can be as ambitious as you want it to be for the decisions you have to make for your agency.
Judicial review is a big subject. I hope it's been made a little more manageable. More on all this, as on all the points in the programme, can be found in the Judge Over Your Shoulder guide and from your in-house legal advisors. Ka kite anō.